Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Divorce Insights on the Law of Division of Assets Between Couples. My name is Amanda Pon, and I'm an associate with Ma Wing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises of 37 lawyers and a support team of 30 people. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and also individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and as well as a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online, and in order to continue with our objective of sharing knowledge, raising awareness, and also encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Which you require specific legal advice to your matter, please contact us for a complimentary legal consultation if needed, details which we will be giving at the end of the talk. As for now, I will introduce today's speaker. One of our speakers is Jasmine Wee. She is an associate in our dispute resolution, corporate, individuals and families, and employment and industrial relation department. She obtained her Bachelor's of Laws with honors from the University of London. Her areas of practice include the laws of employment, corporate litigation, strata, adoption, citizenship, and immigration. She also regularly provides advice to clients on various strata management tribunal claims and have also appeared in High Court and also the Court of Appeal for family matters. Our next speaker is Alyssa Dalila. She is also an associate in our dispute resolution department. She has obtained a Bachelor's of Laws with honors from the International Islamic University in Malaysia. Alyssa was admitted to the Malaysian bar in October 2023. Her areas of practice include general and commercial litigation and family law, which includes expertise in divorce proceedings, adoption, and citizenship. And another speaker for today's talk is Siti Aishah Abdul Rahim. She is also an associate in our dispute resolution and individuals and families departments. She obtained her Bachelor's of Laws with honors from the International Islamic University of Malaysia. She was admitted to the Malaysian bar in 2024. Her areas of practice includes construction litigation, citizenship, custody, family business, and Sharia advisory wills. Today, there are 4 talk points for today's talk. First, we will go through the understanding of how assets are divided in Malaysia, and next, they will speak on what is marital versus separate property. And then the third talk point would be dividing assets and financial considerations. And the fourth talk point would be future interest considerations and case analysis. And at the end, we will conclude with a Q&A session. And now I will pass the floor to our first speaker, Ms. Aishah.
Thank you, Amanda. As introduced, my name is Aishah, and I will be speaking on the first topic, which is the understanding of how assets are divided in Malaysia. And for the second topic, what is marital and separate property, while our fellow Miss Alyssa Dalila will be speaking on dividing assets and financial considerations, while our Miss Jasmine will be speaking on future interest considerations and case analysis. Without further ado, we shall now move on to the first topic, which is understanding how assets are divided in Malaysia. The main statutory legislations that will be the crux of our topic for discussion today is the Law Reform Marriage and Divorce Act 1976. So just a quick introduction to this legislation is that it was enacted on the 1st of March 1982 to bring uniformity to marriage laws for non-Muslims, and it governs civil marriages and divorces for non-Muslims in Malaysia. Bear in mind that this act only governs non-Muslims and not Muslims, and LRA applies equally to both men and women. So when we talk about divorce and the law governing the divisions of assets when it comes to divorce or judicial separations, the main specific legislation is Section 76 of the LRA. So for the purpose of our discussion today, I have reproduced Section 76 here for your reading as shown on the slide. So essentially what this provision entails is the power of the court to divide matrimonial assets in the event of divorce or judicial separation. So under subsection 1, the court is empowered to distribute assets acquired by both parties during the marriage or order their sale and divide the proceeds accordingly. While subsection 2 from A to D outlines the key factors the court must consider in making such a decision. While considering these elements, the court generally leans toward an equal division of assets, reflecting the principle of fairness in matrimonial disputes. So moving on to Section 76, as you can see from the screen, Section 3 and 4 has been deleted. We are going to touch on the amendment part later by our Miss Jasmine V. Furthermore, subsection 5 of Section 76 of LRA clarifies that assets owned by one party before marriage but significantly improved during the marriage, either by the other spouse or through joint efforts, are also subject to division. So this ensures that contributions made during the marriage, whether financial or otherwise, are duly recognized. So in essence, this provision serves to protect both spouses by ensuring that matrimonial assets are divided equitably, taking into account each party's contributions and the overall welfare of the family. So as I've mentioned, and I've also reproduced the Section 76 of LRA previously, we'll take a deeper look on the factors that the court consider when deciding or granting the order to divide the properties. Under Section 76, Subsection 2, from A to D of the LRA, the court, in exercising its power to order divisions of assets, consider several key factors such as contributions of each party, and this may include financial property or work contributions towards acquiring assets or family expenses. And then we also have non-financial contributions, which may include efforts of the non-acquiring party in maintaining the home and caring for the family, as well as joint debts or debts incurred for mutual benefit, which means that any debts incurred for the mutual benefit of both parties. And the court will also consider the needs of minor children, as well as the duration of the marriage. So the Court of Appeal case of Yap Yan Piao and He Wei Ang reaffirmed that Section 76 of the LRA is the key statutory provision governing the division of matrimonial property in the event of divorce or judicial separation. So this provision grants the court the discretion to determine how assets should be divided between spouses, either through direct allocation or by ordering the sale of assets and distributing the proceeds accordingly. The court, in exercising this discretion, follows statutory principles to ensure a just and equitable outcome. So essentially, the fundamental role of the court in this matter is to achieve a fair and equitable distribution of assets rather than treating the process as an assessment of damages or compensation. So this has been clearly established in the case of Ponageswari, where in 2019, where the court emphasized that the function of the court is to make fair and equitable division of the matrimonial assets that exist at the time of the divorce, taking into consideration the factors laid down in Section 76, and it is not an assessment of damages. So this means that the division of matrimonial property is not based on fault or punishment, but rather on principles of fairness, recognizing both financial and non-financial contributions made by each spouse during the marriage. Moving on, we'll take a look at the case of Anaturai in 2023, where it was decided by the Court of Appeal that after the amendments made to the LRA, it provides a significant guidance on the division of matrimonial assets under Section 76. So in this case, the court, in re-examining Section 76, has made several observations. First one is that equal division is not mandatory. So while Section 76, Subsection 2 states that the court shall incline towards equality, it does not require a strict 50-50 split. Instead, the division must be fair and just based on the specific facts of each case. And secondly, judicial discretion remains central in the sense that the court has full authority to determine how assets are to be divided, but at the same time, the court must also take into account the statutory factors as outlined in Section 76, Section 2, as mentioned in the previous slides. And thirdly, the statutory list is not exhaustive. The court is not confined to only the factors mentioned in Section 76, but it may also consider other relevant and appropriate circumstances that impact fairness. And lastly, it is not a strict financial calculation. So the division of matrimonial assets is not an exercise in accounting, but an effort to ensure a just and equitable distribution, taking into account both financial and non-financial contributions. So ultimately, the court emphasized that there is no fixed formula for asset division. Each case must be assessed on its own unique facts and circumstances to achieve a fair outcome. So this case basically reinforces the principle that Section 76 of the LRA provides a framework for judicial discretion rather than a rigid formula. So to conclude, Section 76 of the LRA serves as a crucial legal safeguard to ensure that matrimonial assets are distributed in a manner that reflects justice and equity. So the court here plays a vital role in balancing the interests of both parties while taking into account various factors such as contributions, debts, the welfare of children, and the duration of the marriage. So all of this will be later discussed by the next speakers, Ms. Alyssa and Ms. Jasmine, where they will provide some cases to discuss in details how and what are the reasons that the court may consider in coming to its decision. Next, we will look into what is a marital and separate property. So what does matrimonial assets mean here? The definition of matrimonial assets was provided in the case of Ching Seng Wah, which is a case in 1997, but this case has been cited by the court even as if today. In this case, Gopal Sriram, as he then was, make a significant ruling stating that the Act does not define what matrimonial assets are. However, during the subsistence of a marriage, the expression refers to the matrimonial home and everything put into by either spouse, with the intention that their home and chattels should serve as continuing resource for the spouses and their children. And these assets are to be used jointly and severally for the benefit of the family as a whole. It is irrelevant whether the asset was acquired solely by one party or both jointly. As long as the marriage succeeds, these assets remain matrimonial assets. And such assets may also include capital assets and even the earning power of each spouse. So this definition broadens the scope of matrimonial assets beyond just tangible property, acknowledging that financial contributions, household contributions, and even future earning powers are all relevant considerations. further strengthening the definition of marital assets provided by the case of Ching Sang Wah previously. In another case of Ponagas Wari, it was established that the court's powers may consider the payment of expenses for the benefit of the family, non-financial contributions such as caring for the home and family, as well as the duration of the marriage as key factors in ensuring equitable division of matrimonial assets. So this decision provides greater protection to spouses, particularly homemakers who may have previously been disadvantaged under the older interpretation of Section 76. So just a little bit touching on the amendment. Before the amendment, those who could not prove joint effort in asset acquisition often face difficulties in securing a fair division of assets upon divorce. However, now all assets acquired during the marriage are recognized as matrimonial property, ensuring a more just outcome for all parties involved. So in the Malaysian legal context, matrimonial property refers to assets acquired during the marriage through the joint efforts of both spouses, and this includes the matrimonial home, financial investment, and any other resources meant for the benefit of the family. So as you can see, that's Section 76, subsection 1, the court is obligated to divide these assets between both parties upon divorce or judicial separation. On the other hand, separate property may consist of assets that were acquired solely by one spouse without contributions from the other. So while the court is not required to divide such assets, it has the discretion to do so in certain circumstances. So in order to ascertain what is a separate property, of course, the court will need to firstly consider whether the property falls under the category of matrimonial property, and all of this will depend on the facts and circumstances of the case, which I will then pass the slide to the next speaker, Ms. Alyssa, who will be explaining in detail regarding the dividing of assets and financial considerations.
Hi, everybody. Good afternoon. My name is Alyssa, and I will be speaking more on how the courts divide assets when it comes to the proceedings and what are some of the financial considerations that we can consider or we can mull over and think about in terms of the division of assets. What is the court's stance basically or generally on the division of assets? So in 2019, in Wong Chong Kyu and Lee Hock Seng, the court basically says, and I think this is something that the previous speaker has also mentioned, the court would have to consider firstly this Section 76, that was Section 76 of the Law Reform Marriage and Divorce Act. And also the main guiding principle of the court is that the court shall incline towards equality of division. So they must consider the extent of contributions made by the other party and also the welfare who did not acquire the assets. In another case, in an earlier case, even during this time, even in 2004, the court had already leaned more towards equal division when it comes to the division of assets. So how much the court leans must surely depend on the nature and extent of the contribution and all the circumstances of the case. But at the end of the day, it goes without saying that the court has to do a rough justice between the parties, as there is no measure which can fit all marriages. So it's not a template, it's not a one-size-fits-all approach that the court would take, but what's important is that it would lean towards equal division. And I think the previous speaker also mentioned it's not always going to be 50-50. It ultimately boils down to what the court would decide when looking at all the circumstances and all the assets that are shown to the court. A more recent case in 2024, and this is a higher one, this is in the Court of Appeal, the court actually confirmed or expanded that they should adopt a broad brush approach. So a broad brush approach means we see it as how it's said, it's broad. And marriage is not a business venture, it should not be a detailed accounting auditing process. This is also mentioned previously. And the court also cited an earlier case enforcing and stressing on the fact that it should be, the court's function is to make a fair and equitable division of the matrimonial assets that exist at the time of the divorce, taking into account the factors. A more recent case also in 2025, this year, the court laid down quite specifically what kind of factors or what kind of reasons that the court would lean on or rely on when dividing the assets equally between the parties. So in this case, the court looked at the petitioner's direct and indirect contributions, any contributions to the welfare of the family, the petitioner's sacrifices for the respondent's business ventures. In this case, the petitioner was a housewife, and then also the longevity of the marriage, fairness and equity in asset division. So these are all certain factors and reasons, guidelines for the court to consider when wanting to divide the assets between the parties. And as Aishah mentioned earlier as well, now it's irregardless of whether these contributions were financial or non-financial. So what other factors can we consider that the courts would consider when discussing or assessing the division of assets? So we look at direct contributions, and these are mostly financial. So it's down payments, mortgage payments. Who is the one that's doing the monthly payments for loans, or who is the one that's mostly paying the mortgages? Now, the courts are also now looking at indirect contributions. So household expenses, groceries, utilities, these sometimes are not the same, but it's not borne by the same person who is doing the direct contributions. So sometimes what I think in most cases is the husband bears a lot of the mortgages, down payments and stuff like that, and the wife would use her money for household expenses, groceries and things like that. So these are still considered contributions. But then we're also looking at non-financial contributions like homemaking, childcare, the stay-at-home wives who they don't bring any financial contributions to the marriage, but they do take care of the children, picking them up from school, sending them to school, homemaking, making the house, contributing to making the house a better place. That is also now in the court's consideration in the court's factors for consideration. The court also considers debts incurred for mutual benefits. So house loans, car loans, house mortgages, things like that are also taken into consideration. Needs of minor children, if any, because the custodial parent may receive a larger share, they would receive more money or larger share of the assets in order to ensure the future of the parent and also the child that they have custody over, and also the duration of the marriage. So these are some of the factors that we have seen the court consider, because this is also laid down in the LRA, and this is also over time what the courts have mainly used as a guideline for the division of assets. So after this, I'm going to go into several case studies of some things that you may consider financial considerations when discussing the division of assets. Firstly, EPF. A lot of people ask whether it's a question whether the spouse is entitled to a share of the other spouse's EPF funds once they start divorce proceedings, and are post-marriage EPF funds considered a matrimonial asset that can be divided? Because as mentioned earlier by the previous speaker, any asset that you acquire during a marriage is generally considered a matrimonial asset. So would post-marriage EPF funds also be considered a matrimonial asset? We first look at the case of Yap Yan Piao in 2017. In this case, the Court of Appeal I would say directly said we do not think EPF monies can fall strictly under Section 76 of the LRA unless the statute strictly provides for. The court's reasoning is that EPF funds are personal to the holder, and there are provisions to nominate any person to benefit, but it shouldn't be subject to divorce proceedings. However, after that, the High Court in 2019 also affirms this same line of reasoning that EPF should remain with the respondent and not to be equally shared. And the petitioner herself also has her own EPF. So it should not be considered as a matrimonial asset that should be divided. However, the Court of Appeal in Teo Chi Cheong, and this is more recent, this is in 2024, the Court of Appeal makes it a bit clearer. They said a spouse's EPF funds which have been accumulated after a marriage will be considered as post-marriage EPF funds, and they form part of the assets that can be divided by the court under Section 76 of the LRA. So this is because post-marriage EPF funds would fall within the meaning of assets acquired during the marriage. But then a spouse's EPF funds which have been accumulated before marriage would constitute as a pre-marriage asset. The pre-marriage funds will not be subject to any division. The court further explains that pre-marriage EPF funds can only be part of the assets if it fulfills the two alternative conditions in subsection 5 of Section 76. So I have it on the right screen here, what subsection 5 is, where it says that assets acquired during a marriage include assets owned before the marriage by one party, one, which have been substantially improved by the marriage during the marriage by the other party, or two, by their joint efforts. If the two alternative conditions here, which means if you can say that, or if the parties can prove that the pre-marriage EPF funds were substantially improved during the marriage by the other party or together by joint efforts, then it would fall within the meaning of the assets under Section 76 that could be divided. If not, then it is the court's view that there's not really a way for pre-marriage EPF funds to be substantially improved during a marriage within that meaning by any spouse, by any one spouse or both of them. So it's clear now that the court makes a clear distinction between the two. But in this case specifically, the court still ordered in the High Court, the court had ordered 30% of the balance of the respondent husband's EPF account in favor of the wife. And counsel for the respondent husband submitted that the respondent husband had worked for 15 years prior to the marriage, would be retiring soon, would need that balance in the EPF account for his retirement. That's why they did the appeal, among other things. However, when the appeal was still pending, the respondent husband had withdrawn about 500,000 from his EPF account. And because of this, I would say, because of this scornful behavior, the court decided to allow the petitioner wife's appeal and increase her entitlement balance to 40%, because the court assumed that the withdrawal was because he did not want the petitioner wife to get as much of the balance that she was owed. So this is, I would say, a lesson to people going through a divorce. Don't do something like this. Okay, so that's EPF. What about private retirement schemes? What about gratuity payments or pension funds, things like that? I do have to say that the cases aren't as much as EPF, but courts as early as 1994 have already considered gratuity payments as matrimonial assets. So in 1994, the case of Lim Quen, the court already said to most retired employees, the gratuity payment means much to them and to their families. So it is my view that both the EPF and the gratuity payments are matrimonial assets. That is to say, assets acquired during the marriage by the sole effort of one party to the marriage. The court, as early as 1994, have considered this. A more recent case, Yap Yam Piao in 2017. So in this one, the court was strict to say that EPF, insurance or pension, they don't fall within matrimonial property because they are, the assets in the section refers to property, immovable or immovable property that can be immediately divided. So gratuity payments, which let's say are not received yet, like potential gratuity payments, they are not immediately divided. They cannot be immediately divided. So they wouldn't fall under assets under Section 76. The party that's claiming for this must adduce evidence to prove that the same were acquired during the subsistence of marriage and for purposes of continuing resources of the spouses or the children or the family as a whole. So the decisions of the High Court from 2015 to 2018 have varied in considering gratuity payments and pension funds, private retirement schemes as matrimonial assets. There is, in 2015, in the case of Chitra Danapalan, the court already said there should, in accordance with the principle against double dipping, EPF and gratuity payments should be excluded from a person's net income in determining the division of matrimonial assets. So it wouldn't be included in that. But however, if we do try to apply the same principle by the Court of Appeal in Teo Chi Cheong previously in 2024, accumulation of assets post-marriage would render them to fall under the category of assets under Section 76. If in the chance that the gratuity payments or private retirement schemes were taken out and received during the subsistence of the marriage, the court would be more likely to consider them as assets that would be divisible under Section 76. So it really does depend on the way the judge approaches the case and the assets that the parties bring before the judge. So the next case study, let's look at debts and loans. Who would be responsible for shared loans such as car or property loans and or mortgages? Let's refer back to Section 76. So we know that paragraph B, we can see that in exercising the power, the court shall have regard to any debts owing by either party which were contracted for their joint benefit. So generally, we would say that joint liabilities such as joint loans and joint mortgages which were incurred for the family's benefit are considered as shared responsibilities. So the parties may continue to make the repayment and decide how to deal with the property after the divorce. However, in the event that the parties cannot come to an agreement, then the court may order the division accordingly. So there are, in certain circumstances, the cases that I've cited there, the court ends up ordering the disposal of the assets and the proceeds to be used to clear the loan, and then any balance to be split evenly between parties. But this is also subject to whether the properties are split evenly, shared evenly between the parties, and whether the parties are equally contributing to the joint loan. So a lot of factors come into play. Next, next is shares, stocks, bonds, and things like that. So how would shares, stocks, or bonds be divided between the parties? And what have we seen the courts do? I've found this recent case in 2023, CSM against TCC. So in this case, the parties held shares in a property investment company. The husband had held 90% and the petitioner wife held 10% of the issued share capital. So the respondent husband had also purchased shares in the public listed companies under the wife's name, but he traded them on the stock exchange and retained the proceeds, about 14 million ringgit, and several other shares in the wife's name, approximately about 8 million ringgit. The court, in determining the division, they look looked at the contributions of the wife and the husband respectively in the marriage. So they took into account the husband's financial contributions and the wife's contributions of looking after the home and caring for their two children. So ultimately, the court decided that for the shares in the property investment company, the court ordered the parties to appoint a valuer to value the shares and split the proceeds 30 to the wife and 70 to the husband. And the sale of the proceeds of the shares held in the plaintiff's wife's name are also ordered to be split 30-70. So you might think it's quite, not, I wouldn't say unfair, but you would think that the ratio is quite huge. But it should be noted that in this same case, the husband was also ordered to pay spousal maintenance of 20,000 ringgit a month, arrears of spousal and child maintenance because she left the matrimonial home before they filed the divorce proceeding. So in that span of time, he's supposed to pay maintenance as well. Areas of spousal and child maintenance amounted to almost 1 million, and he was also ordered to pay the child's living expenses at the rate of 5,000 per month, and the child's university fees and rental in Australia at the rate of 489 Australian dollars a week until the completion of the undergraduate degree. So the court was, I would say, quite fair and quite reasonable in deciding the ratio or the division of the shares, as well as received by the wife. As a final point, I'm going to talk about how prenuptial, postnuptial, and marital agreements also would affect the division of assets. So there are certain, I understand that certain parties have created prenuptial agreements, sometimes postnuptial agreements or marital agreements. And agreements of this nature are provided for under Section 56 of the LRA. So you can see here that, so provisions may be made by the rules of court to enable parties to present or refer the court to any agreement or arrangement that was made or proposed to be made by them for the court to consider and express an opinion as to the reasonableness of the arrangement and to give such direction. So you can see in this provision that you can present any agreement or any arrangement made between you to the court, and the court will express an opinion or as to the reasonableness of the agreement or arrangement. In 1998, the court was presented with this matter. So they were presented with a marital agreement and they concluded that, yes, the court does have sufficient authority based on Sections 56 previously to decide on the validity of a marital agreement. A more recent case, actually last year, 2024, the parties did enter into a marital agreement during the course of their marriage after they had registered their marriage. And this agreement addressed everything. There was, in the event of a divorce, how much spousal maintenance, how much child maintenance, issues of adultery and things like that. So they described it as a prenuptial agreement. However, the court regarded it as a postnuptial agreement because it was executed during their marriage but before separation. And in determining the validity of the marital agreement, the court would look at several factors. So one of them is whether the parties did consent to this agreement. And also the court would look at each and every term to see whether it complies with legal standards. So in this particular case, the court's position was varied. So there were certain terms that the court did not uphold, and there were certain terms that the court did uphold. For example, in this particular marital agreement, the court did not upheld the child custody terms because they were not in the best interest of children. And there was also a term in the agreement where the party initiating the divorce was to pay a penalty sum to the other party for initiating the divorce. And this was also not upheld by the court because the court did not find it reasonable. And also, there was another clause in the case, in the marital agreement, where it permitted the respondent husband to keep a mistress. So the court gave a lengthy reasoning for this. I won't dive into it, but the court essentially said this wasn't unlawful. With these variations and dismissals of the terms, the court eventually conducted its own assessment of spouse and child maintenance. So even though they had an agreement that they both consented to as to how much child maintenance and spousal maintenance that they wanted to give, the court still made its own assessment. And the court, after assessing and looking through each and every term of the agreement, still conducted its own assessment of spousal and child maintenance, even though there was already an existence of the marital agreement. So after all of that, what are some conclusions, takeaways that I can summarize for you? is that one, the court derives its power by way of Section 76 to order the division. So it's not just the division between the parties of any assets, but also the sale of any such assets. And secondly, assets are firstly determined to fall into either category, which was mentioned by Aishah earlier, with some courts ruling that anything acquired post-marriage is considered as marital assets, especially if it was substantially improved by joint efforts. And the third, several factors considered, including contributions by each party, either financially or in kind, which means welfare of children, maintenance of marital home, non-financial contributions. And also, lastly, that pre- or post-nuptial agreements will be considered by the court, but its validity will be subjected to legal standards or will be subjected to law. That's all from me. I'll pass the floor to the next speaker, Jasmine.
All right, afternoon, everyone. My name is Jasmine, and I will be your third and final speaker for the day. Thank you very much to my colleagues, Alyssa and Aishah, who have provided a great insight in the division of matrimonial assets and also determining what is a matrimonial asset and what is a separate property. So, over the decades, as you all know, societal changes have happened. There are emerging legal challenges which have necessitated amendments to ensure that the Act, here in particular the LRA, maintains its relevance and also its effectiveness. So since divorce is becoming increasingly common, amendments to the Law Reform, Marriage and Divorce Act 1976 have been long awaited in order to better protect children and wives, in particular in relation to matters referring to welfare of the children and also division of the matrimonial assets. Right. So with what I'm about to tell you today, there is an overlap between the topics of what my colleagues had previously discussed, but I hope that you can take it as a summary of the talk because in my opinion, it is necessary to give you this refresher so that you'll be better able to understand the case analysis portion. So we start with evolution of the law, and I will bring you through the amendments to the LRA 1976. And listed here are the reasons as to why this change had to come about or why it eventually came about. So of course, you have societal changes in the way that people view divorce differently now. Of course, it's more common than what it used to be. There are also emerging legal challenges because every marriage is different, every divorce is different. So on a case-by-case basis, this has resulted in landmark decisions or very relevant decisions which have addressed challenges that somebody may find that is relevant to their divorce and their marriage as well. So the amendments had come about on the 15th of December, 2018. Pre-2018 amendments, so among these amendments concern the maintenance of children of a marriage. Before the amendments came about, divorced fathers were required to maintain a child only until the child reached 18 years old. Presumably because back then, I think times are different now. I think these days children enter the workforce much later than they did during my parents' time. And now post-2018 amendments under Section 95 of the LRA 1976, you are now able to find that divorced fathers have to maintain their child or children until the completion of a child's higher education or training. So what this means is it no longer stops at 18. These days, I believe I can speak for the masses that children beyond the age of 18, they tend to still be in college pursuing their degree, maybe master's or PhD and things like that. And this is something to consider, and it's important because financial burden of a higher education is much higher than when children are in their early years. So it's not the same as paying for government school fees, private school fees, paying for uni is a whole separate matter. So higher education or training, however, remains undefined under the Act. But if we were to take it literally, it would simply mean going to university, going to college, or even vocational school to obtain licenses. This is a case called Tong Sek Yi against Ho Shu Jun. This happened in 2019, so after the amendments. So there was an application by the husband to amend and vary the terms of his decree nisi, which is an order that you obtain after your divorce has been essentially legalized. So there was also a separate application by the husband to change his second child's surname. The parties here were legally married prior to the birth of both of their children. And I would like to note here that the oldest child, the girl, has shared the same surname as the biological father. However, the second child did not because the divorce petition was filed 4 days after the birth of the second child. The Wife here, the petitioner, had discovered that her husband had been unfaithful and proceeded to file for divorce immediately. And of course, subsequently, the marriage was dissolved, whereby terms on care and custody of the child, control, maintenance of the children, even separation of property was recorded by a consent order, where both parties had to come to agreement. Further in the case, the wife here had registered the name of the second child under her own surname rather than the husband's surname. So now two children have differing surnames, even though they are completely biologically related. So the wife here had resisted to the application of the husband to change the child's surname. And the issue here was because the wife had claimed that prior to recording the terms of the decree nisi, the terms of their divorce, the husband had actually agreed and had given up his rights to raise his issue, or rather given up having put his surname on his son's birth certificate. And here she brought up the issue of the husband relinquishing his rights of raising this issue ever again, because they had already talked about it before in discussing the decree nisi. However, for reasons unknown, the issue of this surname was not recorded in the consent order, which is why it came about in the open court. So here, the husband had apparently agreed to relinquish his rights in exchange for not having to pay maintenance to his wife and also not having to bear the tertiary education costs for the second child. This is a portion of the judge's judgment in deciding this case. And here he made it a point to note that at the time the decision was delivered, it was prior to the amendments coming into effect, which affected the LRA. But even back then, the judge and the court had strongly urged the father to bear the educational expenses for the child, at the very least for his first degree, in the same manner that he had agreed to do so for his elder child, his daughter. And the reason for this is because the courts need to ensure that a child's future education is not affected by bitter divorce between parents and, of course, warring parents. And it's recognized as by way of an amendment to Section 95 of the LRA 1976. He goes on to say that this amendment then provides that succession of child maintenance upon completion of a child's higher education or training came into operation 15th of December 2018. So at the time of the judge writing his grounds, which is the reason for giving his decision, the legal position was that child maintenance, it stops at the age of 18. However, he had urged the father to do otherwise, to support the child further than 18. Right, now we move on to division of matrimonial assets. As my colleagues had mentioned before, division of assets is determined by whether or not matrimonial assets were acquired by joint effort of both spouses or simply the sole effort of one spouse. And I would like to note that assets acquired by a sole effort or one spouse will usually result in a greater proportion of the asset, but it's not tried. So post 2018 amendments under Section 76 LRA 1976, there is consideration of non-financial contributions, as my colleague Alyssa and also Aishah has mentioned before, made by spouses towards the family. Generally, from what we can see in cases and also from our own personal experience, it is usually the wife that often either gives up a career or maybe takes a backseat in a career to raise children and also to manage a home, which then entitles a husband to go out and do what he does in order to provide for the family. So the considerations, non-financial considerations here that be taken into account would be also expenses paid for by a spouse for benefit of the family, and this can be by either spouse. And by this, generally the spouse that continues to work and the spouse that stays at home, of course the spouse that continues to work will make a bigger chunk of payment, but we also often find that there's an arrangement where the working spouse may provide some form of an allowance, or perhaps the non-working spouse is doing some things on the side, they have an income of their own, whatever it may be. They also make small contributions. So this can be things like paying for quit rent, buying groceries, paying for the water bill, the electricity bill. All these things will be taken into consideration. So the extent of contributions made by either party who did not acquire assets to welfare of family by managing home or caring for family. So this is what I mean. And duration of marriage will also be considered. If the duration of your marriage, say for example, is only a matter of 6 months, of course, it is very unlikely that you may have made any sort of significant non-financial contributions. And the longer the marriage, and of course, as things unfold, you will find that over time, you would have given more and more of yourself to a marriage. So that is something to think about. And this will be significant to spouses that have left the workforce to care for the welfare of their family. Now, I'm going to talk about the case of Yap Wen Piao against He Wee Eng. Here, it was a 37-year marriage on paper, which had resulted in the couple having 3 grown-up children. The wife was, prior to the divorce, or rather prior to the marriage, a practicing nurse, and the husband was a medical doctor. So upon their marriage and also the birth of their children, the wife had decided to become a homemaker. Even though on paper their marriage had lasted 37 years, the couple's marriage had actually broken down 15 years prior to the divorce. So they were separated. However, they had continued living with each other under the same roof. So here, initially, when it started off, the High Court had ordered that properties, assets, businesses, whatever it was they own together. We often refer to this as putting items in a pot. So whatever was in the pot, it was meant to be split evenly and equally, or as equally as possible. The husband here had appealed to the Court of Appeal on the basis that the division of property was grossly unjust and had completely contravened Section 76 LRA 1976. And this is because the husband claimed that some properties and assets were acquired by him for investment purposes after his separation from the wife. To further elaborate on this, just quickly, he had some properties in Australia, apartments, and also some shares and bonds and stocks, which he had acquired within that 15-year separation period, even though they were still legally married. And actually, one of the properties in Australia were placed jointly in both their names. And this is because he had intended for this property to be held on trust as an eventual gift for their daughter. So the husband made further claims that the wife had never made any financial contribution towards the acquisition of these assets that I mentioned earlier, nor did she ever look after the matrimonial home or care for the family, and she had never lived in the Australian properties as well. That aside, the court held that they upheld the High Court's orders with regards to the matrimonial home, and also there was an issue of a burial plot that she was asked to return to the husband. But however, they made some variations to the High Court order regarding their other properties, the properties that I mentioned earlier that were obtained within that 15-year period of their separation. So the court made a point to note that if Parliament had intended all assets acquired during the marriage to be equally divided, or divided as equally as possible, they clearly would have said so. And it is not for the court to fill any gap in the law and construct provisions of the LRA 1976 by widening the scope of relief, regardless of how other jurisdictions have treated separation or matrimonial property, whether it's our neighboring countries, foreign countries, it doesn't matter. So division of matrimonial property was permissible as of right. So what I mean by this is, as I mentioned earlier, there is a pot. So things that you have obtained during your marriage fall into this pot, and is permissible as of right in that it's free for equal distribution. However, things that are non-matrimonial property, which I will go on to give you a distinct sort of a difference later, the court has discretion to deal with non-matrimonial property justly as they see fit. So currently, Section 76 does not define what constitutes a matrimonial asset. So for convenience, matrimonial assets are classified into matrimonial property and non-matrimonial property. So there is a difference. There's a different type of matrimonial assets which are acquired before somebody has been married, but we'll be getting into that today. Matrimonial property here relates to property that has been acquired by both parties. So they have put in an equal amount of effort, or as equal as possible. And non-matrimonial property relates to property acquired by sole effort. And this is very relevant here. I found this case to be very unique simply because usually when people say, if you are still married, whatever assets or properties that you acquire, people, I think, immediately assume that everything would be split in half. So here it is unique because they've stayed married for a very long time, but essentially they have not been living as husband and wife, or they've just been strangers under one roof. This case here addresses challenges and ambiguity in a division of property upon dissolution of a marriage in relation to property acquired during a marriage. So here the case further went on to note that there is a nexus test for parties to satisfy, or whoever is making such an application. And the test for this generally is to see whether or not the asset or property concerned, whether there's an enjoyment and or use for current common purpose. So this would include things like cars. For example, you've driven your children and your family around these cars to wherever they need to go, vacation homes, which parties regularly visit or maintain together. And of course, as my colleague Alyssa mentioned earlier, EPF and pensions. So EPF and pensions are not something to be considered for a current common purpose. So it belongs to whoever had earned this EPF or pension. So this is paramount because it protects the interests of minor children, especially. Now, moving on to inheritance rights, we won't be touching too much on inheritance law here, but there is a little bit of a overlap when it comes to inheriting after a divorce, especially when there has been a Muslim conversion. So prior to the amendments to the LRA, non-Muslim family members were completely unable to inherit from a converted spouse unless it has been specifically bequeathed. And even then, there are certain types of property that are not allowed to be bequeathed to non-Muslims. So after the amendments, we now have Section 51A of the LRA 1976. And this section allows for applications for distribution of matrimonial assets of a spouse who has converted to Islam but dies before the marriage is dissolved. So the people that are entitled to apply under this section are, of course, surviving spouses of the deceased, surviving children of a marriage, and also parents of the deceased. Now, under Section 51, Sub 1, LRA 1976, okay, essentially it is like this. If you married each other and both of you were non-Muslim, and throughout the course of your marriage, one of you converts to Islam, it does not mean that your marriage is automatically dissolved. You are still legally married. However, if you do not wish to stay married due to the difference in religion, Section 51 provides you an avenue to apply for a divorce. Prior to the amendments to the LRA, only the spouse that was a non-Muslim was entitled to apply for divorce under civil law under the LRA 1976. However, now, after the amendments, both the Muslim and non-Muslim spouse is fully entitled to apply for divorce under civil law on the basis of conversion to Islam. And essentially, if you have applied for this divorce, the distribution facts to consider are the same as if two non-Muslim couples were to proceed with for lack of a better word, regular divorce. So here they will consider the extent of either party's contributions made by any interested parties in money, property, or works towards acquiring matrimonial assets or even payment of expenses for the family's benefit. And they will also consider any debts that are owed by the deceased and also any interested parties which were contracted for their benefit, and also the extent of contributions to the welfare of the family by looking after the home or caring for the family. And further things to note, they will again consider the duration of your marriage, and especially important are the needs of the children, especially children that are under 18 who essentially can't fend for themselves. Rights of interested parties under the Distribution Act 1959, which is what regular inheritance law falls under, of the deceased if they had not converted to Muslim. So these are all things that court will look into. So there's no set formula, but these are just things that we have observed from previous case laws and also our own personal experience. These are other facts to consider. It doesn't really have anything to do with distribution of assets, but personal gifts from anyone, this usually comes from inheritance from someone else, they generally will remain with the recipient, which would be with the deceased's estate in this case. Any dowries that are paid may be asked to be returned or retained. Spousal maintenance is not applicable. In a divorce, spousal maintenance is applicable when you are, it appears to be a typo here, and also child maintenance. So these things are to be considered when you are applying for a divorce in a case where one spouse has converted to Islam. We move on to the final case here, which is Hal against Haas, and this is a very recent one in 2024. So in this case, a husband had filed for divorce on the grounds of his conversion to Islam. So just a little bit of backstory here. Both couples, when they were married, both were non-Islam. And sometime throughout the course of his marriage, the husband had decided to convert. The wife did not convert. And as time went on, the Muslim husband had actually found a new family. So he had formed a new family, and essentially they were no longer husband and wife for all intents and purposes. However, both parties had delayed in filing their application for divorce. So when the husband finally filed for divorce, the wife had filed a cross petition, which is cross application, alleging that the husband had cheated, and this was her grounds for divorce. And she then further sought arrears in spousal maintenance and sought that the division of their matrimonial assets be done equitably, equally. And so here, this case is quite unique due to the couple's delay in filing their applications here. If I'm not mistaken, about 10 years had passed. So the wife had known about the affair, the wife had known about his separate family, everybody was aware. Here, in this case, it was held that in addressing spousal maintenance, it is crucial to underscore the principle examining the means and needs of both parties involved. So this provision is mandated through evaluation and not only through the financial capabilities of the petitioner. So what is meant by this is, I often find that when clients or leads, they come in for asking about divorce, a lot of people are very concerned that if my paycheck is a certain figure, will the court ask me to pay more than what I can afford, or a large chunk of my salary and things like that? So I'm here to tell you, no. The court will not ask you to pay what you cannot afford, more than you can afford. And also, they will take into consideration whether the person asking for this maintenance also has a job, whether they have their own money. So all these things will be taken into account. It's not just a matter of a man giving a woman money and things like that. So there's also the task of dividing matrimonial assets, which is prescribed under Section 76, and there's classification of assets as matrimonial, which could not solely be determined by registered ownership. So what that last one means is, in this case, specific to this case, the property that was owned, some of it was in joint names, but most of it was in the name of the husband. However, due to their long marriage, they essentially shared usage of these assets and also properties. And it further held here that with regards to the matrimonial home, the husband was asked to transfer his half of the share to the wife and also to pay a certain sum for maintenance of the home, because the courts had held that the matrimonial home here was the wife's sole residence. And the couple in question here was also actually fairly old. The husband was in his 70s and the wife was also thereabouts. And the court had taken into consideration her age and also how familiar she was with the property, considering how long she had lived there. And they decided that the wife should continue to reside in the matrimonial home and that she should own it. Since the husband had already had a second family, he had moved out, he had moved on with his life, essentially. And they also further considered her role in maintaining the household. So the husband had essentially worked their whole marriage and she was a homemaker for a large portion of it. But if she wasn't a homemaker, if she wasn't nurturing the family, wasn't managing the home, it probably would not have allowed the husband to make the type of money that he was making prior to the divorce. Moving on, so the wife's further claims for division of the husband's company shares was also dismissed. This is because the husband here had ceased involvement with the company, having retired. He was no longer a director, he was not an employee, nothing. And the wife, when filing this claim, I would like to note, whoever is applying for these claims, if you're going to stake claim over something, the burden of proof will lie on you to prove your contribution to it. So if you're going to say, I should have half of this house because I had made payments to quit rent, my advice to you is to keep those receipts and also to show any form of proof to show that this money had come from you and not from anybody else. Because if you are just going to make a bare assertion in court saying that I had purchased this sofa, I had painted this house and all these things, but you can't back it up, and there's not much point to it. So here, the wife's claim to the husband's company shares had relied solely on bank account statements from the company from the year 2000 to 2010. So they were very much overdue or expired, for lack of a better word. So because of a lack of current documentation or evidence of the husband's current involvement in the company, the court decided not to award her any of the company shares. And the court had also considered whether interest divided would directly impact the husband's ability to fulfill familial obligations. And this is in relation to his second family, where he had younger children, very young children. The courts further held that the wife's claims for division of their vehicles were also dismissed because there is no current documentation confirming status of vehicles. So in this case also, the wife had provided documentation on the vehicles, which were about 10 years to 15 years old. And the courts had also made it a point to note that due to the prolonged inaction of this couple to finally get a divorce, all these things, this was a main deciding factor in what they decided to grant to the wife and also to the husband. So if you're going to sit on your rights, you cannot expect the court to then reward you with things you think you deserve. So if you are going to make up your mind, if you're going to stake a claim to something, our advice would be to do it promptly and do it quick. So one of the vehicles here were also owned by the company that the husband used to work for. So it would have been unequitable to divide property that doesn't even belong to them. And further on that, the claim of division of monies alongside any jewelry and watches, this is also something that is very commonly brought up in our concerns with our clients. So here, the wife had claimed that this jewelry and watches and all these monies had been owned by her husband. However, she had like to provide specifics and also any supporting evidence to this fact. So the wife failed to provide any descriptions of the items that she was staking a claim to, nor did she produce any documentary evidence to substantiate her assertions. The husband, however, claimed that the jewelry and watches were obtained after they had separated. Whether there is any credence to this claim, either way, the burden of proof in the existence of such assets had laid with the wife, and she did not satisfy the burden of proof. Yeah, so that will be all for me today, and I think I will give it back to my colleague Amanda for our Q&A session.
Thank you, Jasmine, Alyssa, and Aishah for your insight. We will now move on to our Q&A session. We have a few questions from the audience, but due to our lack of time, we will just go through a few. Our first question reads, how does the court treat assets that are co-owned with third parties, such as siblings, business partners, etc.? And also, would property gifted from, say, parents be protected from division? I think this question could be answered by Aishah.
Hi, Amanda. Okay, so to answer the question, a quick answer would be like properties owned with third parties do not really fall within the category of matrimonial property unless the claimant can prove that personal funds were provided for the acquisition of those properties. That is usually highly unlikely that the court would grant an order with respect to such properties, as this would also affect the rights of the third parties who are not parties to the divorce proceeding. And the second part to the question, which is on the gift or inheritance. So the answer is it most likely depend on what parties intend to do with the gift or inheritance, usually by way of conduct. So I've mentioned in my in the slides previously, where the court laid down the definition of matrimonial property in that it refers to home everything which is put into it either by spouse with the intention that their home should be a continuing resource for the spouse and their children to be used jointly or severally for the benefit of the family. So it depends on the conduct of the parties. And additionally, I would like to just mention a case that was not highlighted in the slides previously, but as a development in terms of the law. There was a case that was recently decided in February 2025, HAI and PAI, where on the regards to properties in relation to inheritance, the court decided that since there is a commingling of the nature of the assets integration into the matrimonial property, the court was of the view that this gift, the inheritance gift, should be treated as part of the shared matrimonial assets rather than solely derived from the respondent's inheritance. So again, it depends on the facts and circumstances of the case and the conduct of the parties, then the court will then assess. I think that should be the answer.
Thank you, Aishah. Okay, I hope that answers the question. The next question would be, can parties decide together that certain assets are not subject to asset division at divorce? For example, if the couple decide to each keep their own EPF, could the courts exclude those assets, or would the assets still be subjected to division according to fair and equitable principles? Alyssa, would you want to answer this question?
Okay, yeah, I'll take this one. I think one thing that's important to note is that most of these cases that we have mentioned throughout this talk are, or at least just the concept of division of assets by the courts in general, are mostly for single petition divorces or the contested divorces, which are only filed by one spouse, which is filed in and of itself is filed because there is a disagreement about the division of assets. So if there are no concerns about the division of assets or other things like spousal maintenance, children maintenance, then there's no necessity for parties to apply for a contested single petition divorce. So if you can agree on certain assets not being subject to asset division and you agree you want to keep your own EPF, then we would advise that you apply for a joint petition. You can just set down the terms, agree to the terms, you apply for a joint petition, it can be done in 6 months. So you don't have to go to the courts division. So I think that's something that maybe we didn't mention earlier, but yeah, most of these cases, asset division in general is mostly for single petition divorces.
Thank you, Alyssa. Okay, due to our lack of time, we will take our last question for today's talk. Okay, the question reads, since prenuptial agreements validity is still subject to law or in some way uncertain, Malaysian lawyers allowed to draft prenuptial agreements for clients? Jasmine, do you want to take this question?
I'll take this one. Thank you, Amanda. All right. To answer your question, there's nothing illegal about lawyers drafting prenuptial agreements, so long as the effects and the validity of such agreements have been explained to the interested parties. However, with more recent cases that we're looking at, a situation where some judges in particular, they do tend to give effect to prenuptial or postnuptial agreements simply because agreeing to such an agreement itself shows that parties are willing to come to terms or at least agree on the specifics, and the court is empowered to give effect to the agreement between parties.
Thank you, Jasmine. Okay, before we conclude, I have a few announcements to make. So first, please join us again for our upcoming talk, which will take place on the 9th of April, entitled Recovery of Common Property in Malaysia. And also you could fill in our feedback form and tell us what you thought of today's talk. The link to the form will be posted in the chat. And thirdly, we would be grateful if you could follow or like our social media accounts. We're on YouTube, Twitter, Instagram, LinkedIn, and Facebook. And fourthly, if you would like to speak with any of our lawyers, we offer a complimentary 30 minutes consultation over the telephone or over video conference. Please fill in the form on our website, and also the link will be posted in our chat box. So to all our guests, thank you for joining us. We hope you have found today's session informative and useful.